contract. So it will regulate now dispute resolution mechanisms. So this is one type of arbitration agreement that you have, one that is contained in a document between the parties. You also have what is known as a submission agreement. So it could be that the parties themselves, a dispute has arisen between the parties, and the parties may have provided, even in the agreement, that they want to submit to the jurisdiction of the courts, and that the courts will resolve their disputes. But a dispute having arisen, they can then enter into what is known as a submission agreement, where they agree to resolve their dispute outside of the court system. So this then now becomes the consent, and it allows the parties to appoint an arbitrator who will then now adjudicate over the issues. So we've got what is known as a submission agreement. We also have what are known as agreements incorporated by reference, agreements which are incorporated by reference. You tend to find most of these in construction and engineering related projects. This is where you'll find these, where you have perhaps, or even in some other complex projects, it could even be a procurement related agreement, which provides an agreement which is incorporated by reference. So for instance, it could be parties to a dispute saying that in one agreement, we agree to the ZNCC arbitration rules and things like that. So then the arbitration agreement is incorporated into the parties' agreement through reference. That is what this essentially means. So these are the essential types of agreements that we have. The unique thing about the arbitration agreement is that it is a standalone agreement. So the most fascinating thing about an arbitration agreement is that it is a standalone agreement. So for instance, if a contract is found to be void or to be null, it does not necessarily or by implication nullify the arbitration agreement, because the arbitration agreement is considered to be separate. So if one looks at Article 16 of the model law, it then provides now for a doctrine there of separability. So an arbitration agreement or an arbitration clause is considered to be separate from the original contract of the parties. So if the original contract of parties is found to be null, void, or any other thing, the arbitration agreement still stands. So the parties can then now have recourse to resolve whatever dispute they may have through the process of arbitration, which makes arbitration itself very, very unique. Now, I want us to talk about what are known as multi-tier clauses, because they also fall under arbitration agreements, so that we can just have an appreciation of this. Now, most contracts you'll find that they have or they may provide for multi-tier clauses. Again, you'll find these in most construction and engineering related contracts where you'll find these provisions. You also find these if you're dealing with municipalities, local boards, or urban councils, and things like that. So you'll find them when we're dealing with some of these organizations whereby they are sort of chain processes that you have to take, or step-by-step processes before you get to arbitration. So as you can see, I've already highlighted there what a multi-tier arbitration clause is. It is an escalation clause, an escalation process. Some of the most common steps are expert evaluation, whereby an expert can be called to make a valuation of something. It could be through the process of negotiation. We should also remember that arbitration is by contract, it is by agreement, and it is done in good faith. So the principle here of negotiation, again, in good faith, is one of the other elements. So a multi-tier clause could be one whereby before a dispute is referred for arbitration, the the parties should have at least tried to meet some of these requirements if they are set out in an agreement. So, for instance, an agreement can specify that the first process to resolve the dispute is through negotiation. This tends to work where the parties have a long established relationship and they want to continue their relationship. And you have these various processes whereby the parties can come together and negotiate. So these could be the CEOs of the companies coming together to negotiate. It could also be through mediation. And again, you find this in most construction and engineering related projects where a lot of mediation may be required. It's unfortunate that we don't have a mediation center per se, but we do have trained mediators in the country, and some of them are the ones who specialize in these areas. So I've also noted down there some cases which can be of assistance to somebody who, when they want to find out more information about multi-tier clauses. Now, I just want you to know that the obligation to proceed to arbitration can only be evoked or brought into effect if these preconditions are met. So, if there are any lawyers here, they'll understand when we're talking about these preconditions. You have to meet these things before we go to the next step. Otherwise, there'll be no arbitration agreement. So, for instance, if one cannot then apply for a stay of proceedings if a matter has been referred to court if they have not gone through the necessary processes of negotiation and mediation. If they've gone through the various processes or the multi-stages which may have been set out in an agreement and those have been met, and a parties to institutes legal action, one can then apply for a stay of proceedings in terms of Article 8 of the motor law. And these cases will be of assistance at that particular juncture. Now, for the dues, the minimum features of a valid agreement, what I call the dues. So the things that should be found in a typical arbitration clause or a standalone arbitration agreement or a submission agreement or arbitration deed are these items I've highlighted here. So number one, the minimum features, this is just the minimum. There could be more depending on the facts of the case or the facts of a particular contract, the complexities or the amounts involved. And also maybe even some of the things we'll be discussing as we go. But these are some of the things that, number one, the business lawyers need to understand, or the lawyers drafting the arbitration agreements need to understand fully. So number one, it is the procedure for the appointment of an arbitral tribunal. How are the parties, number one, going to choose the tribunal or the sole arbitrator? So the dues, each arbitration agreement should provide for a procedure for the appointment of an arbitral tribunal. It should ideally provide that if it is going to be a sole arbitrator, how are the parties going to appoint the sole arbitrator? Are they going, in what timeframes are they going to do this under? So for instance, the parties are supposed to mutually, so ideally parties are supposed to mutually agree to the appointment of a mutual arbitrator. This is if it's a sole arbitrator to be appointed, and they are supposed to choose one arbitrator. They can come up with a list of names. If they fail to come up with a list of names, they can then perhaps appoint if somebody, if they have not already included this, was something that will also highlight there, an appointing authority, somebody to make that decision on their behalf. In two instances, there's this can be done by an appointing authority, or this can be done by the court. So in order to not have to go to court to find out or to appoint or to choose somebody, the parties should agree ideally on the procedure of the appointment of the tribunal. So do is to have a procedure for the appointment. Number two, we should also have the powers of the arbitral tribunal can be set out, that the tribunal has the powers or the authority to do A, B, C, or D. So the principle of arbitration is based on what is known as party autonomy. So the parties have got authority to make certain consent. So they can consent to the arbitration having perhaps extended.
Hello, hello, Prince. Hello. We seem to have a technical glitch there. Um,
Absalom?
Hello, Prince.
Yes. So I'm now using
Yes,
this machine. I think we got cut off.
yes, we got cut off. We had lost you for about almost 5 minutes, I think.
Oh my. And there I was busy going on.
Sorry
Oh, my
about that.
apologies for that.
Even your video is stopped.
Oh, really?
No longer see
All
your
right.
screen
Sorry.
also. Mm.
Oh, shame. All right. I'll try and use this machine. Apologies for that. Yes, I can hear you.
Hi, Prince, are you back?
Hi, can you hear me?
Yes, we can, and the screen is now back.
All right. The screen is now back. All right.
I think last time
Oh,
you had spoken about the second aspect, the power of the arbitral tribunal.
all right. So I'll carry on from there. Again, ladies and
Thank you.
gentlemen, apologies for that. We will um I'll try and also just speed it up for the purposes of time. So just to confirm, Absalom, you can still see my screen, yes?
Yes, I can clearly.
All right. Okay. No, thank you. I like the emphasis on clearly. Yes. So we're talking now on the power of the tribunal. So the parties themselves can set, they can limit the authority or they can extend the authority of the tribunal. So this is one of the things that should be at least catered for when drafting an agreement. That the parties can also provide, depending on the complexity. Some of these things also depend on the complexity of the type of agreements that will be drawn up. If it's a lawyer drawing up on behalf of a client, the complexity of that, or if they're in-house lawyers as well, also understanding the complexity of the agreement, they can also specify on the power of the tribunal. However, we do have provision whereby in terms of Article 19 of the model law, if the parties fail to agree, that is now Article 19.2, the arbitrator has got the authority to become master of the procedure and also make, what can I call it? Also make, direct how the arbitration proceedings should be conducted. So these are the things that should be ideally found or put in the arbitration agreement. The third thing that should be found, so you should do, is to have the number of arbitrators. So in arbitration agreement should ideally identify the number of persons who are going to resolve the dispute. So we tend to find that in matters which tend to be non-complex, the number is ideally one arbitrator who will be appointed, the parties can appoint to have one. If it is a rather complex agreement, the parties can choose to have a panel. There's no set out number, but the minimum number or the most recommended number, if we call it that, is to have at least 3. It would be odd to have an odd number because if the 2 arbitrators cannot agree, how then does that go? How is the deadlock to be managed? So the number of arbitrators as well, it is very, very important. More often than not, the issue of number of arbitrators will appear where parties are drafting international arbitration agreements or international contracts. The ideal number there will be 3 arbitrators which are appointed or chosen. So at minimum, you should have this in the arbitration agreement. The arbitration agreement should also specify the place or the seat of arbitration. This is the law that is going to be governing the arbitration itself. So please take note of these words, place or seat, because this again is its own subtopic by itself, including the one that is below the venue of the arbitration proceedings. But each arbitration agreement should specify the law that is going to be regulating the arbitration proceedings. And we'll see this as on the next slide. Ideally as well, an arbitration agreement should specify the venue of the proceedings. So for parties that are in Harare or in Zimbabwe, they could provide that the venue, this is the place where it's going to be held, where the place where if there are going to be any oral hearings and things like that are going to be held, they'll be held at a particular place. So this could be in Vic Falls, Nyanga, Harare, Bulawayo, you name it. So the parties as well can identify the venue. I think when I was speaking about item number 1 and number 2, that is the procedure for appointment and the power, I also there spoke briefly about the rules that govern the procedure. So at this juncture, it's also important to mention concerning arbitration that there are ideally, let's call them 2 types of arbitration. There's what is known as ad hoc arbitration, and there's what is known as institutional arbitration. In Zimbabwe, we tend to have, we apply the ad hoc method in that we don't have our arbitration centers are not institutional arbitration centers like in most countries. So you'll find that in Kenya, they've got their center. In Kigali, they have a center and things like this. Ours is not yet that advanced, although we are working towards that. So you'll find that ideally parties will have or should have rules set out. So as a default, we've got what are known as the ancestral arbitration rules. So these are rules which have been designed to help persons in ad hoc arbitration, such as in Zimbabwe, where the parties can now have these. So the parties can then now choose to have these or to incorporate them into the arbitration agreement, but they should ideally provide for rules which cater to the procedure. So all the other issues concerning perhaps the routing of communication, how is communication to be effected? If parties want to substitute an arbitrator, how is it to be conducted? So it will detail or at least outline the various procedures which are there. So this can be found in the rules. So at minimum, or it's something to do or to factor in arbitration agreements, is to have rules. Then most importantly for me on this one, as we continue, is the language of the arbitration. How is the arbitration to be conducted? So you'll find that in cross-border contracts, this is something that is very, very important. Recently, I was dealing with a case involving one party from Panama, another party from Angola, involving a company that is in Zimbabwe. So these countries, all the parties, all the people, they speak different languages. So you need to have a language which then caters now for how are we going to resolve the disputes. So if a dispute arises, in what language are we going to conduct it in? So it's more often than not you find this in international arbitration. In Zimbabwe, we've got 16 national languages. So one can choose as well from the 16 official languages that we have, but that's just stretching it. But that's just to show you the importance of language. So at most, an arbitration agreement should also have this. The next, all right. We are still together, you can see me?
Yes, we can. We have the slide on refresher exercise now on the screen.
Excellent, yeah. So perhaps now just to give us a break from hearing my voice, yeah. This is just a refresher exercise for us to look at. We won't have to answer these questions, but this could be somebody's homework whereby they can go and take time to see whether or not they've understood, number one, some principles concerning arbitration. So I'll try and read, but I'm sure everyone can see. Let me just move one or two things. All right, so I'll just read. If any dispute, difference, or claim arises between the parties in connection with this agreement, or the validity, interpretation, or alleged breach of this agreement, or anything done or not done pursuant to this agreement, the parties shall refer that issue for resolution by arbitration. Both parties shall agree to appoint an arbitrator. The arbitral proceedings shall be conducted with the provisions of the Zimbabwe National Chamber of Commerce Arbitration Center, and the laws of South Africa shall be applicable. The proceedings in such arbitration shall be conducted in English. The venue and the place of arbitration shall be Mauritius. So for homework for somebody, the first question there is, what is the governing law of this agreement? This is something that we just spoke about when we were highlighting some of the essential features. Number two, it is what is the seat of this arbitration. Number three is what arbitration rules apply. It's not every day that you're going to see an agreement such as this, but it does happen that we come across agreements such as this, of course, without the questions at the end. Another question to then ask is this a valid arbitration agreement? These are some of the things that one can ask and do some homework on. But these are some of the things now, like I said, it's a refresher. So you can exercise your mind concerning this. So I'll just give people just a minute just to reflect on this before we move to the next slide, which is now going to be concentrating on some of the things that we should not do and some of the things which are already also outlined in the things that we have covered and in this refresher exercise before I leave the time to you.
There we have it, ladies and gentlemen.
I'll repeat again.
Can we have those who wish to venture answers raise their hands so that we can give them a chance to do so? Any hands there? The first question, what is the governing law in this agreement?
Perhaps people are afraid, yeah? No, it's all right.
What is the governing law there? I think it's fairly straightforward, particularly the first question there. What is the governing law agreed upon in this clause?
You want to give it a shot?
Do I see the names of the participants there? I see there's 33 of us on the call, and none of us is brave enough to try and venture an answer. I see Vigilant Musekiwa. Do you want to attempt?
No, I think Absalom, we will continue. Like I said, it's just an exercise. We don't have to answer it now. Others, they may be afraid, but this is now the arbitration is not necessarily straightforward, but some of the things that we see in the arbitration agreements are things which are very, very important. Like we then emphasized when we began. Remember, the focus of this is the do's and the don'ts of arbitration, the do's and the don'ts of arbitration. So you'll find that as a lawyer, you may come across a contract such as this. It will then be at that point very, very important for you to know what laws are applicable. Are they the laws of Mauritius? Are they the laws of South Africa? Are they the laws of Zimbabwe? In this particular instance here, the law that governs this agreement are the laws of South Africa. So the laws of South Africa will be applicable to resolving a dispute for parties who are perhaps in Zimbabwe, parties who are...
Sorry, I had been kicked out. Prince. I'm back now. On which question are we? The first one been answered.
Oh, yes. No, I was now answering. Perhaps people are too shy. Yeah? So I was now mentioning
that's okay. Okay.
I presume, yeah, the presumption is that they are shy. But the focus here is, remember, we're talking about the do's and the don'ts of arbitration agreements. I would not draft my arbitration agreement in this particular manner. There's a way in which I would draft mine. You know, I've even got a model that we're going to look at and discuss. But we do tend to come across agreements such as this. So if, as a lawyer, you come across in-house or external counsel, you come across agreements such as this, the first thing to ask is what law is governing this? Number one is this a valid arbitration agreement? If it is, what laws govern this agreement? Are you familiar as well with the laws that govern the arbitration? So more often than not, we tend to enter into some of these contracts without necessarily paying attention to some of these clauses. So for instance, if we're signing service level agreements and things like that, or other contracts with parties who are from outside of Zimbabwe, we tend to agree to laws that we may not be familiar with, which is why it's always good to also know a bit of the laws like English law and things like that. So here, the law that governs this agreement here is the law of South Africa. We emphasized when we're talking about what is the seat and the place of arbitration. The seat here will be, again, South Africa. When we're looking here now at the arbitration rules which apply, these will be the Zimbabwe National Chamber of Commerce rules. So the seat is different from what is already emphasized and put there as the venue of arbitration. It says venue. So any meetings which are to be conducted, so these could be procedural meetings. These meetings and any other such meetings can take place in Mauritius. So we can find ourselves in Port Louis, travel to Port Louis, and conduct our meetings there, any place in Mauritius. So this was just a refresher. Now we want to go and talk about what are known as the 7 deadly sins. And this is what is perhaps going to help us on the things that we should avoid doing. So the do nots, the things that we should not do when we're drafting arbitration agreements, these are things now that we want to focus on. So like I said, these are 7 sins. Let's call them 7 sins. And the reason why I call them 7 sins is because I've derived this from Mr. John Townsend. I've already also put there where you can find more information concerning this and how it can then help us when drafting agreements. So for those who may want to know more about how to draft agreements, this is something I would recommend finding this journal. It will then help you. The first one there, what it deals with or what it talks about is what are known as pathological clauses. Pathological clauses. This is where you find an agreement which does not specifically say that the parties resort to arbitration. An arbitration agreement is supposed to be specific to what it is, so that the parties are going to finally resolve their dispute by way of arbitration. So when I'm looking at the first scene here, and a typical example would be parties saying that they agree to resolve the matter by arbitration, and the courts of Harare, should they proceed by litigation, the commercial court in Zimbabwe has jurisdiction. That is also then now known as a pathological clause. Funny enough, you'll find that the ICC Court of Arbitration in Paris has a lot of these, or has dealt with a lot of these. Most of them actually come from several agreements that they had prior to where they are now. But that's the first sin there. So when we are drafting, we need to be very careful and make sure that we emphasize that any dispute should be finally resolved by arbitration. Should be finally resolved by arbitration. Sin number 2 is the sin of inattention. An arbitration agreement does not have to be legalistic or very, very exhaustive. It should ideally, like I said, have the minimum features which I mentioned earlier. So the sin of inattention, this is whereby the parties do not pay particular attention to certain things. So this could be a business lawyer, or a lawyer, or any other person who is drafting this agreement. And I recommend that these agreements are drafted by lawyers, and lawyers who also have an understanding of arbitration and the various types of arbitration or the rules of arbitration, not just, we are getting to a point of training, but ideally we would want people who know how to draft this. So inattention, not paying particular attention to certain fundamentals, procedure. For instance, the way parties fail to put things to do with procedures and things like that. So we should pay particular attention to the things that we want to be resolved. Another one which then ties into this is what is known as the sin of omission, leaving things, the necessary things out. There are certain things that need to be included in these arbitration agreements. So we always need to make sure that we can bring in these elements. So for instance, here when we're talking about omission, one could be looking at the issue of language. You omit to put the issue of language, the place or the seat, or the venue of the arbitration. This is by omission. So we need to pay particular attention when we are drafting agreements, and one can even make a checklist when they look at the minimum features, the do's. They can have a checklist of the things that they can look at and consider, and this will then help us. The next one there, we've got the sin of over specifying things. It's good to be as broad as possible to try and cater for various things, but remember, these agreements or arbitration agreements are essentially meant to be on a case-by-case basis, so that when you're looking at a particular case, it may require, it's not every single case, mind you, that requires or should be dealt with or resolved by arbitration. There are certain cases which would be ideal for the courts to deal with. But here, just concentrating on this
sometimes an arbitration agreement can overspecify certain things. I'm currently doing something with some people in Nigeria, and recently they have a new act, the Arbitration and Mediation Act of 2023. And Section 56 provides for what is known as an arbitral review, arbitral tribunal review, whereby the parties can agree in an arbitration agreement to have a second arbitration, a second tribunal review the decision of the first instance tribunal. That, for me, is going to be something worth looking at, because it deals now with over specifying how are they going to do it. That agreement is going to be over specified. The qualifications. So 1 year we'll be talking about the qualifications of people, perhaps even where they're coming from and things like that. We need to make sure that it is not necessarily as basic as possible, but as broad as possible, and captures the necessary things, which then now touches on the other scene of unrealistic expectations. We need to understand, or to have realistic expectations when it comes to drafting these agreements. Sometimes you may want to have an agreement which is resolved within a fortnight, whereby it is a straightforward case which can be dealt with within a short period of time. I'm pushing for what may be known in Zimbabwe as a small claims arbitration, whereby small claims themselves can go through arbitration and can be conducted within a short period of time. But an unrealistic expectation may be a way to appoint. The first arbitrator is to be appointed, or the arbitrators are to be appointed within 7 days. After 7 days, the parties are supposed to meet and conduct a hearing with the arbitrator, or a preliminary meeting with the arbitrator. After that, the parties are supposed to make submissions within 7 days. After those 7 days, the arbitrator is supposed to make or to render an award. That is an unrealistic expectation. So these are the things that we need to pay attention to. We also need to pay attention to what is known as litigation envy. Most people are comfortable in court. They are very, very comfortable in court. They know the court rules in and out. And now with the commercial court rules, they are very, very familiar with those court rules. And they want to now bring in to arbitration the mechanisms or the rules of court. So this scene essentially is dealing with where parties can agree, or will put in an arbitration agreement that the parties agree to finally resolve their dispute. And the rules to be applied are the rules of the High Court, of the Zimbabwe High Court 2021, or the commercial court rules. So the question to ask then is, if the rules of the court are applicable, do the parties have a case management meeting? Do parties conduct? How is evidence to be done? Because those rules provide for strict evidence. Strict evidence is not a requirement in terms of the Arbitration Act or in arbitration. It also provides for pre-trial conferences or meetings. It provides for a trial and things like that, things which are not found in arbitration. So having litigation envy. So we need to also be particularly and avoid having this type of envy for litigation, or bring in these technical things. And unfortunately, you find that most retired judges, when they then now become arbitrators, this is how they tend to conduct proceedings. So it's something to be careful of when drafting an arbitration agreement, to actually know rules. So one can take time to actually study rules and to know rules. So if a firm is big enough to have a department, this is something that the department or the interns and associates can actually venture into or look at. And the sin of overreaching, this will be the last one here, whereby, a party overreaches to such an extent that the arbitration may not appear to be fair to the other party. So this could be, for instance, the claimant, where there'll be a claimant and a respondent. This is just in a simple arbitration. Remember, now we've got more complex agreements which can provide for more parties, or multiple parties or participants to arbitration. You find, again, complex contracts, your construction, even finance nowadays with solar projects or energy-related projects. You find that you've got various players, the banks, and all these people. So you could find that the claimant, for instance, who specified that they've got the right to appoint they've got the right to come up with the list of names of the arbitrators, and that the respondent can only choose from that particular list which has been drawn up by the claimant. Such a thing is overreaching, you're overextending. So we should pay particular attention. So to answer the question of the do's and the don'ts, the do's are the things that we find the minimum requirements. Those are just minimum requirements. And the don'ts are the things that we find here in this slide concerning things that we should try and avoid. And for more information, again, we do have what I've already listed there. And now I'll go to the final part of this presentation, which is going to be concerning what we can call, perhaps for now, our model clause, or something which is close to what we can call our model clause for inserting into our agreements. Please take note that I've added the ZNCC there as an arbitration center. I do hope one of these days that we'll embark on this, but I've just put it there. So please, for now, for anyone, please don't include this particular point until they've agreed to this. But we do have 3 centers in Zimbabwe, which Absalom has already detailed or narrated to us when he was giving the profile, and I'm on those 3. So you can have them there as the appointing authority. So you can choose the ADSC, IMA, or CAC. You can put them there. But the model clause should read ideally something like this. Any dispute arising out of or in connection with this agreement, including any question regarding its existence, validity, or termination, shall be referred to and finally resolved by arbitration under the ancestral arbitration rules at present in force. So number 1 here, what we see is that for you to refer a matter to arbitration, there has to be a dispute. You cannot refer a matter to arbitration if there is no dispute. So here we see that if there is any dispute which arises from any of these things, that you can even expand that dispute should be or will be referred to arbitration. And when it's being referred to arbitration, the purpose of the arbitration is to finally resolve the dispute between the parties. And here we're also identifying or choosing applicable rules of conduct for the arbitration, that the rules are going to conduct the arbitration are the ancestral rules. So for instance, if the ZNCC has arbitration rules, you can then insert there the ZNCC arbitration rules. If the Commercial Arbitration Center had rules in Zimbabwe, of which they don't, and most agreements provide that they do, and they don't, they could also provide there that the commercial arbitration rules in Zimbabwe. It should also identify that the arbitration proceedings shall be conducted in accordance with the provisions of the Arbitration Act. So, like I said, we've got an Arbitration Act, which may require, of course, some amendments because it was, came into being in the 30th of September, 1996. So a lot of time has since passed, and a lot of changes have taken place concerning even the 2006 amendment to the model law itself. So to play catch up, we may also need to amend, but it's ideal as it is. So we should have something like that. You should also choose to have in an arbitration clause an appointing authority. There may be certain circumstances or certain things that may require an appointing authority. So for instance, the parties want to replace an arbitrator. It could be that the arbitrator has passed on. How are they to do it? Believe it or not, I actually got a call some time ago from an organization here in Zimbabwe, and somebody had passed on who was an arbitrator in certain matters, and they now wanted to find out whether or not they could hand over the files to me. I had to explain to them very carefully that that's not how it works. There's a particular process in which they have to go through. So this is the importance then now of an appointing authority. So we need to have an appointing authority, and the appointing authority can then now be whatever institution in Zimbabwe that is there. Like I said, we've got 3 that are well known. So these could be the appointing authorities, and their responsibility is essentially to administer the running of the arbitration and things like that, or even make the appointment of an arbitrator or arbitrators. Also, there is the number of arbitrators to be appointed, either a single arbitrator or a panel of arbitrators. The place of the arbitration could be the town or the country, and the language of the arbitration as well. People need not worry about all these other things. I do believe that this can also be circulated to members so that they can also just take note of some of the things. So if you want to know more concerning arbitration, how to draft arbitration agreements, the procedures in terms of arbitration, there are some recommended textbooks by our universities in Zimbabwe, which offer law, and in other universities as well, whereby they teach business. They have now recommended that students get these literature. So you've got the book by Davison Kanokanga, which is Commercial Arbitration in Zimbabwe, by Juta and Co., which is going for $40. You also have another book by Davison Kanokanga and Prince Kanokanga on the ancestral model law on international commercial arbitration in Zimbabwe. A commentary, so this is a commentary on the Zimbabwean Arbitration Act, again by Juta and Company in Cape Town, which is going for $60. One can purchase these books online from Juta and Co. In South Africa, or they can purchase them here in Harare from Kanokanga and partners. So these will be good books for people to have, which will help them with the knowledge of arbitration, in training of arbitration, or even in drafting agreements. So, Mr. Elsno, I think this is the end of my presentation. Siyabonga, thank you.
Thank you so much, Prince, for that powerful presentation. I believe that we need to quickly invite questions. The presentation has been, it has provoked a lot of thoughts amongst us, and I believe we do have questions that we want to Prince to assist us with before we let him go. I have now opened that opportunity to members on the call. Can you raise your hands, those who would want certain questions answered or certain aspects clarified? Does the silence mean that we have all understood each and every aspect of the presentation? If so, then can we go back to, I see 2 hands up. There is Chamu there, Chamu Tembo, followed by Mrs. Moyo. Can you go ahead and ask your questions in that order?
Okay, thank you so much for the presentations, and thank you so much to ZSCC for organizing this. It was really quite insightful. But what I wanted to ask is, if we already have these agreements that are running, but we just realized from this discussion that there are some there's some information or this issue to do with arbitration which is not properly done. What can we do? That's my question. Thank you.
All right.
Do you want me to?
Do you want me to take? Yeah, I think you should go. You should go ahead, ma'am. Then I'll answer together.
Can we take another question so that you answer both? at once.
Yeah, no, yes. Okay, thank you. Prince, thank you very much for that insightful presentation. It's very good because I know that we have a number of attendees who are not necessarily legally qualified, but who are business people who, as you heard from the first question, obviously have contracts in which the issue of arbitration clauses is very relevant. What I wanted to ask you for the benefit of the audience is you touched on the issue of as a business person or as a lawyer, the first thing to look at is whether the agreement for arbitration, which is treated as a standalone agreement, is valid. Can you, for the benefit of our audience, explain what happens where the arbitration agreement is deemed to be invalid? What happens then to any dispute which may arise between the parties, or where, for example, there has been the sin I beg your pardon, the sin of omission, in the sense that perhaps the seat of the arbitration or the language or the venue has not been dealt with in the arbitration agreement. And then the very last question I would ask is what happens where there is a dispute as to what law should govern an arbitration agreement, where you have several parties from different countries. How do you determine at the end of the day which law is going to govern the agreement, taking into account, of course, what you said about the risk of the dominant party overreaching?
Yes, there we go, Prince.
Absalom, I'm seeing that your people. But no, these are very good questions, and thank you for these questions. And I like the fact that not everyone is from legal, and that we can also touch on people who are in business or in trade. So the first one would be depending on what the contract itself says. The parties have, like I said, it's based on consent. So the parties can make an agreement to certain things, and they can reduce the agreement into writing. So essentially, this could be an amendment which is made to the arbitration provision if one is able to bring about some change. So this will be making certain changes to the arbitration agreement. I just want to also just highlight when I'm saying this that most of us may actually find ourselves in these agreements which actually provide for arbitration without actually knowing that they provide for arbitration. I'll give you a very basic one. Any single person who contracts with the government, almost, if not all, procurement contracts signed with the government provide for the resolution of disputes through arbitration. It is actually an area in which one needs to then now explore, because we call it procurement arbitration, and whether or not, if one is to pay attention to what we're talking about, and particularly the sin of omission. If one is to look at a procurement contract, the dispute resolution clause, does it also not venture into what then is called the sin of omission when we are dealing with that, or inattention when we are dealing with that? So one should actually then go and study if they are doing any business with the government of Zimbabwe or any ministry. They'll actually be surprised that they actually provide for arbitration. But to answer your question, it is through an amendment. So if you find yourself in a situation whereby certain things may need to be done, you may require an amendment, or you may also now then require the services of a lawyer to then review your arbitration agreement to see how it can best be correct. Then
Hello, Prince. We seem
Yes, can you
to
hear me?
we seem to have lost you. I think if you could come again on the last bit of your answer.
All right. So I was saying that at the end of the day, it may actually just require that if these are just mere laymen, these are just business people who are entering into these contracts, they may then now require the services of a lawyer or lawyers to be able to go through their documents, so to submit the documents to them for review, to say, hi, we've got this contract, may you please kindly go through this contract and tell us its weaknesses and things like that. So I call it a legal audit. So I conduct legal audits to see our contracts, how best can we strengthen our contracts and things like that. So a legal audit may be something that is required for these contracts and can cure some of these things that we find in our contracts.
Thank you so much, Prince.
Hello? Yeah.
The responses.
Hello?
Yes, we can hear you, Prince, although from time
Can we
to
have
time
some
you
more
might
questions
come in
there?
a bit.
All right. Let me
Hello, do we have participants?
let me try and answer your
Hello, we seem to be losing you, Prince.
All right, can you hear me now?
Yes.
All right. So I think I have to speak closer to the mic. So you'll find that in Article 7 of the model law, you'll find Article 7 of the model law when you open the Arbitration Act. So like I said, it's the first schedule that you'll find with the Arbitration Act. So Article 7, if one goes there, this is where they find the essential definition in the form of what an arbitration agreement is. So all the elements and things that we're talking about. So for instance, if the parties had not written down the arbitration agreement or had not provided, had it made an oral arrangement. So myself and Epsilon, for instance, agree that we are going to start buying and selling cars. And should we have any disputes, we will refer them to arbitration. And we don't reduce this into writing, be it in the form of exchange of letters, emails, and things like that. There is no arbitration agreement. So in such scenarios, if one did now go to court and say they've got an arbitration clause, in that case, the case is likely to fail in the form of writing letters, or even that show a record.
Hello, Prince.
Hi, can you hear me?
Yeah, we had lost you a bit again.
Oh, wow. All right, let me just mute and unmute. All right, I've also stopped sharing the video. Perhaps this will help. All right, so I was saying that in such a case, me and you may have agreed to enter into some agreement, which is not reduced, right? Right? In such a case, when one appears before court wanting the matter to be referred for arbitration, in such case, the court will not likely application
We can't hear you now. Sorry, Prince, can you come again on that?
Can you hear me now?
Yes.
All right, hold on.
Can you hear me?
Yes, we can. Hello, Prince.
Hi, can you hear me?
Yes, now we can hear you. Hello.
Hi, it appears that it keeps dropping on my ends, yeah.
Yeah, looks like.
But if possible, what I would do, yeah, I do believe that there's an attendance, and I'll also communicate some of the. I'll try and answer if possible some of the questions and forward them to one of the staff members at ZNCC so that they can communicate this with the participants of today's meeting, whereby I also try to be as elaborate as possible and just to try and cater for some of the things because I may not be able to answer all of them because we keep getting cut off.
Thank you very much, Prince. I think at this juncture, it remains for me to request the chairperson of the AGR and Legal Committee, Mrs. Sarah Moyo, to give us a vote of thanks. Mrs. Moyo.
Yes, thank you, Absalom. So, Prince, on behalf of the ZNCC, ADR, and Legal Subcommittee, we would like to thank you very much for making this presentation to our members and also to other participants who are not necessarily members of ZNCC. It has been very insightful. And I believe that ZNCC will be even more motivated to establish an institutional arbitration center. As you correctly observed, there are so many laws which require arbitration. And we agree with you that really there is need now for arbitration to be offered as a compulsory training for those who are undertaking business studies as well as legal programs. And then obviously to the participants who have joined this meeting, thank you very much for taking time out of your busy programs to be with us this morning. We know that there are many other events that you could have attended, but you chose to be with ZNCC this morning. So we really appreciate your attendance. We apologize that there was a bit of a glitch towards the end, but I think the bulk of the presentation was very clearly heard when Prince was making his presentation. And last but not least, we thank our moderator, Epsilon Michandiwona, and the ZNCC National Office for hosting this meeting. So with that, I will say good day to you all and hope that you have an enjoyable Friday. Thank you very much.
You, Mrs. Moyo.
Thank you. Bye, everyone.
Bye.
Thank you. Goodbye.